representing West Kenya Sugar Company Limited. And the issues we are raising are the following. West Kenya Sugar Company Limited was the highest bidder when bids were invited at 36 billion Kenya shillings. Rao, the receiver manager, who of course was dealing with the bids on behalf of KCB, awarded the tender to the lowest bidder, Sarai Group, at Kenya shillings 5.8 billion Kenya shillings. You can see the difference between the highest bid and the lowest bid, 30.2 billion Kenya shillings. When one is evaluating bids, a receiver manager appointed by a secured creditor, he or she owes a duty, not just to Kenya Commercial Bank, but to the shareholders, because ultimately the shareholders are the ones who put money in the company. Owes a duty to the farmers, who are also creditors, who have delivered their cane to Mumias, and for many years they have not been paid. Owes a duty to many other creditors. West Kenya Sugar Company Limited would have been able to clear all the debts, including KCB debt, within a period of 18 months. Would have revived Mumias Sugar, would have been operational, and all the debts would have been paid, including to the farmers who have not been paid, including several billions in tax that KRA is demanding from Mumias Sugar. So there has to be an explanation. And in the course of these proceedings, one of the issues will be that we want Kenya Commercial Bank's Chief Executive, Joshua Oigara, who of course was liaising with the receiver manager they appointed, Rao and Oigara, to come and explain to the court, explain to the Kenyan public the logic behind rejecting 36 billion and accepting 5.6 billion Kenya shillings. There has to be some explanation, and they owe a duty to come and give that explanation. Rao has responded and talked about West Kenya Sugar Company would have become dominant. And I want to explain very, very clearly that in claiming that issue, bringing that issue of dominance, first of all, he is factually incorrect, because you know Kenya consumes more sugar than it produces. So if you want to know who is dominant, dominance is not about milling of sugar. Dominance is about the market share. So you would have to bring in who is importing the sugar. You know, we don't produce enough. Number two, the issue of dominance legally belongs to the competition authority. And the competition authority is the one with the data that would show who is dominant, what percentage, what volumes any particular miller is milling or selling, and that sort of thing. Rao doesn't have that data, doesn't have that competence. The other third point, which is very, very critical, is that if you look at the Competition Act, specifically Section 42, it is illegal, it is a criminal offense for the receiver manager to have handed over the assets of Mumias, in particular the lease, the 20-year lease, without the prior approval of the Competition Authority. And that's what he did. So even as we sit here and we argue, that the issue we'll be arguing is that the court cannot be called to aid in the violation of the law, in the commission of criminal offense. We will be arguing that the handing over of that lease is a complete nullity because of lack of authority by the Competition Authority of this country. So when we talk about corruption, because inference is the only inference that one can make, is that there is something inexplicable when a receiver manager would reject 36 billion and opt to accept 5.8 billion Kenya shillings. Let me ask Martin Betonga. What?
Maybe just to reiterate what the court has said, we have filed an application to join into these proceedings. The court has given directions on what needs to be done. Parties are to file their responses to those applications. And we are expecting that when we resume in March, the court will make the orders for us to participate in these proceedings and ventilate the issues that Senior Counsel has raised. So for now, let's wait for the court directions, and then we'll be able to ventilate those issues heavily for the court to consider and make a determination.
Counsel, he said they have come in as who?
Yes, we've made an application to join into the matter as a plaintiff. That is the 6th plaintiff in this matter, as the highest bidder.
Let Kibe Mungai, who filed the proceedings on behalf of this farmer.
Short and clear. Well, we present shareholders of the company, under the company's law, the most important. We represent shareholders of Mumias Sugar Company Limited and farmers. From shareholders, the best interest of the company, which is supposed to be upheld by the receiver manager, is to ensure that the heavy debt of load that weighed down Mumias into receivership is paid in the quickest manner possible and handed back to the shareholders and the board of